Morning.
Good morning.
Thank you for dressing appropriately for court. So let me see. All right, so discovery, was that completed?
Yes, Your Honor.
All right, and today is the plea deadline date. So is this going to be a jury trial or have you all reached an agreement?
We have reached an agreement. We're in agreement with all the terms. It's been a written plea agreement. We've gone over it with Mr. Lunsford, and we do have an agreement. One of the things that the state wants to accomplish prior to the plea is restitution up front. The state, and I don't want to speak for them, but my understanding is they need a little time not only to identify the specific recipients of the restitution by name, addresses, who the check should be made out to, and the amount. It's a substantial amount of money, and we are able to pay that before sentencing. So I would suggest perhaps 30 days to get those numbers done so that we can present the agreement to the court.
Let me make a suggestion. I would suggest that you all do the plea today, and I will set it in 30 days for sentencing. And then if for some reason and it will be set for a restitution hearing before the sentencing. And then if there's an objection to the restitution, or if there's an issue with the restitution, we can handle it then.
Part of the plea bargain is that it would be paid up front. So as long as it's before sentence is imposed,
yes,
then that'd be acceptable to the state.
All right.
Yes.
All right, folks, welcome back to the channel. Today's courtroom drama is one you do not want to miss. Picture this. A defendant strolls into court thinking today's just a formality. She's got what looks like a generous plea deal on the table. The prosecution is nodding along, and she probably thinks she'll be home in time for lunch. But here's the twist. This judge, he's seen her name before. And not just once or twice, but pages of priors. That's right. Nearly 4 pages of criminal history.
So to give everybody plenty of chances to get the restitution amount, and you all can confer off docket. Is that good for everyone?
That's fine with the state.
Yes.
All right. So if you guys will get the plea paperwork ready, I'll take the plea, and then we'll set it for a sentencing. What date would that be on, Ms. Ferguson? Well, no, it's going to be a PSI and TAP evaluation, because that will give you more time with a PSI and TAP.
Yes.
I can do it. So it'll be October 20th. And what I can tell you is PSI and TAP, those are 2 completely different things. So they're going to be 2 completely different dates for you to see probation. So make sure you meet all of those dates.
Yes, ma'am.
So October 20th, is that good for everyone?
Judge, I have a federal trial that day, but I don't think it's going to go. If we're a couple of weeks out, that looks hard, then I'll talk.
Okay. All right. So we'll set it for October 20th, and I'll wait for you all to do the plea paperwork. Once you've completed that, just let them know and we'll take it out.
Thank you,
All right. Thank you. Who else? All right. Court is going on the record. Court is calling 2025 CR 1023 State versus Mark Lunsford. Can I have parties announced?
Austin Stout for the state.
Sam Cogger and Sam Locke from Schmucks.
And are you Mr. Lunsford?
Yes, sir.
Counsel, have you received all discovery and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Lunsford, did you review the application for deferred adjudication or community supervision with your attorneys?
Yes, sir.
Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney?
Yes, sir.
Did you understand it?
Yes, sir.
Counsels, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, except the state does have a motion to waive counts 2 through 55 and proceed only on count 1.
Any objections? Did you review the document entitled Court Admonishments with your attorney?
This is where things get really interesting. The prosecution is standing there, practically begging the judge to accept the deal, but the judge isn't budging. Why? Because he sees a pattern the rest of the courtroom is ignoring. For pages of criminal history doesn't happen by accident. It tells a story of someone who's been given chance after chance and never learned. Now, think about it.
Not follow your plea and gives you more than you bargained for. The fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Do you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine?
Sure.
Counsel, has your client been able to provide you with any defenses?
We discussed the defenses with him, Your Honor.
All right. Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Lunsford, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, sir.
Did you understand if you're not a United States citizen, by entering into this plea bargain agreement, you can be deported, not allowed naturalization or re-entry into the United States?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorneys? Did you understand it?
Yes, sir.
According to the plea bargain agreement, the state is proceeding on count one. They're asking that your punishment be assessed at 10 years in the prison. There's a $10,000 fine. State is opposed to your application for deferred adjudication. There's to be restitution in the amount of $297,000.
Classic courtroom move right here. The defendant starts talking like the past doesn't matter, but the judge isn't letting her skate by. And honestly, this is where the tension hits a new level. She's frustrated, her voice is rising, and you can see she's not used to being challenged. This isn't just about the charges on paper. It's about attitude. Judges pick up on tone, body language, even sarcasm. And when you're standing there with a rap sheet longer than most resumes, the last thing you should do is get sassy with the bench.
They're supposed to defer.
All right. So did you understand that to be the plea?
Yes, sir.
Do you understand that the state is opposed to your application for deferred, but they are recommending community supervision?
Yes, sir.
So do you understand if the court does not grant your application for deferred adjudication, but if the court were to grant your application for community supervision, then the court will have followed your plea bargain agreement? Do you understand?
Yes, sir.
All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 10 years. There be 200 hours of community service restitution, a cap of 60 days in the Bexar County Jail, no contact with the complainants listed, and felony anti-theft course in MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to count one, how do you plead? Guilty, not guilty, or no contest? I'm sorry,
No contest.
state any evidence?
The state is offering State's Exhibit 1 and all attachments. And Your Honor, I would just want to clarify for the record that count 1 is first degree felony, but it is for money laundering over $300,000, not less than.
All right, thank you. I think what do you call it? The sign is incorrect. You know, when they do the sign, the less than sign and the more than sign. All right. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Sure.
Did you understand it and sign it in all the appropriate places?
Yes.
And counsel, I'm assuming you have no objections to the stipulations being entered?
We do not, Your Honor.
All right. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Sure.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review this.
This right here is the turning point. The judge is laying down the law. Literally, he's not just reading her record. He's performing it for the courtroom. Every prior charge, every probation violation, every failure to appear, it's all coming back to haunt her. This isn't just about punishing one person. The judge is sending a message to everyone else sitting in that courtroom, waiting their turn. If you think the system is blind, think again. Repeat offenders are going to get noticed.
For sentencing on October 20th. Your court date will be at 9 a.m. I will base my decision upon any evidence that's presented.
Sure.
All right. Anything else before we go off the record?
No.
All right, once you sign the reset form and speak with probation, you'll be excused. All right, thank you.
Thank you.
Thank you.
Your Honor.
Thank you.
But the one time I did roll my R, everything just went haywire. So I don't think the universe was expecting it. All right. So today is plea deadline date.
Yes, Your Honor. So we were recently hired on this case,
Mhm.
just a couple days ago. We still need to go through the discovery, and Ms. Laraga has informed me that she has previous experience at the mental health court. We need to explore that also, if we could. So if we could get an extension on this plea deadline, we'd appreciate that.
All right, who's the prosecutor on this case? Shakira Laraga? Right, did you confer with the state?
Yes, just briefly, Your Honor, just to let them know that we've been just recently retained on the case. So we need to evaluate the discovery.
All right, so today is plea deadline date for them. She's previously been in a treatment court in the county court. And the last time we were here with this, there was supposed to be a consideration of the fact that she was in a treatment court.
Okay. We were just hired a couple days ago. I didn't realize that she'd been previously brought up to the state.
So, Ms. Ferguson, set this for the second week in September, and that will be your plea deadline date.
Thank you, Your Honor.
Thank you, Judge.
What date?
And there it is, the moment that seals her fate. Instead of staying quiet, instead of letting her lawyer do the talking, she opens her mouth and says exactly the wrong thing. You can almost see the air leave the courtroom. The judge's face changes. The prosecution is smirking, and the defense is probably sinking in their chair. This is where ego collides with authority. Judges don't forget these moments, and they definitely don't let them slide. What do you think? Was this just nerves making her snap, or was it pure arrogance?
I've received all discovery. I've tendered a discovery acknowledgement to the courts. And I believe the client wanted to address the court, but he formally rejects the offer.
All right, so do you want a jury trial or a bench trial?
Ma'am, look, I feel like I'm being coerced into signing for something that.
Now, here's the thing. Let me explain the process to you. And I want you to hear me and internalize what I'm saying. So anytime somebody is charged with a criminal offense, once it works its way to the DA's office, they'll review it. They may take it to the grand jury. Once a grand jury indicts a case, which doesn't mean anything, it doesn't mean you're guilty. It's just telling what you're charged with. It gets assigned to a court. And then you get assigned an attorney, and you're probably assigned an attorney before it's even indicted. Then your attorney will make sure that they have all of the discovery. So what is the discovery? The discovery is usually everything that the state says they have in order to prove that you committed this offense beyond a reasonable doubt. That's the way they look at it. That's the way they say, yep, we have enough evidence. In this court, I take it a step further. Once your attorney has told me that they've received all of the discovery, I make sure that the state tenders an offer. Now, the state's offer can be whatever they think whatever they want it to be. They're supposed to be seeking justice. That's what it says in the code. So whatever they offer you, that's what they're offering you. Your attorney will present that offer to you. You can say, I'm not accepting that, which is called a rejection.
The hammer has officially dropped. The deal is off the table, and instead of a smooth plea, she's now looking at the real weight of her actions. This is courtroom drama at its finest. Everyone walked in expecting a quick, quiet resolution, and now it's turned into a public lesson on accountability. Here's the kicker. Judges don't do this often. Overloaded dockets usually mean plea deals are the norm. But today, this judge made a stand. Do you respect his call, or do you think he just wanted to make an example?
Whatever you feel railroading is, if you feel railroading is the state is not making an offer that you find acceptable, then to you, that's railroading. But they make their offer, and then once they make their offer, you have choices to make. So if you want a jury trial, and this court will give you a jury trial. If you want a bench trial, a lot of people think that they get to determine, yeah, I want a bench trial, therefore I get one. But the state has to agree also and say, it's okay for you to have a bench trial. What a bench trial is that I or the judge who's sitting here will hear whatever evidence is presented and make a decision on whether you're guilty or not guilty. Jury trial, there'll be 12 people sitting in the box, 12 random people, right? They'll sit in the box. The state will present their evidence to that jury or either to the court if it's a bench trial. They'll do that by calling witnesses. Witnesses will come and testify. Hypothetically and normally, this is what usually happens. The state has to prove that it happened in Bexar County, because if it didn't happen in Bexar County, then I don't have any jurisdiction. They usually have to prove an on or about date, and they do on or about dates, so you'll know we're talking about on or about this date. This is when we're saying it happened. If it's a robbery, guess what? Complainant will come in and complainant will say certain items of value were taken from me without my consent, which means I didn't give this.
And just like that, it's over. The defendant thought she was walking out of here free, maybe even a little smug. Instead, she's cuffed in front of everyone and escorted out. The courtroom gasps. The lesson is clear. Disrespect the process, and the process will eat you alive. Now, this isn't just punishment, it's theater. Judges know the public is watching, and sometimes an arrest in court is about showing that no one is above the rules. Do you think this was justice served or overkill for...
You're the person who possessed the drugs or had care, custody, and control of it. So that's where we are. So if you are not going to come to an agreement with the state, then your next setting is going to be a jury trial date. And you will be brought over dressed in whatever clothing you have at the jail. If you wish to be brought in any other civilian clothing other than what you have at the jail, you'll need to sign a release so clothing can be brought to you. So do you want a jury trial or a bench trial, or are you reaching an agreement with the state?
The reason why I don't want to take what the state is offering me because it's I don't think prison and
Here's the thing. Let me just tell you, whatever the state is offering you, I'm not involved in what their offer is. But what I can tell you is, if you look over in that box, I guarantee you nobody in that box will raise their hand and say that they think prison is right for them. I've had people, when I was a defense attorney and when I was a prosecutor, they would be charged with murder. They were like, prison's not the place for me. Nobody thinks prison is the place for them. You may once every 200 cases have somebody who'll say, yeah, I deserve to go to prison for this. But normally people don't say that. So I don't need to hear about your negotiations with the state.
So what did we learn today? A sweet plea deal can turn sour real quick when a judge decides enough is enough. For pages of history finally caught up to this defendant, and one bad comment sealed the deal. Instead of walking free, she walked straight into custody. Cases like this remind us that courtroom drama isn't scripted. It's real, raw, and unpredictable. And that's why we break it down here for you.